Hi everyone, how's it going? This is immigration attorney Moumita. How is everyone doing? Thank you for joining me. It's Saturday, and I thought I would just come on here to talk more immigration because I know that the Citizenship Act of 2021 is out, and a lot of questions about what does it mean, how is it going to help me, how will it help improve my life, and am I eligible? So if you haven't already joined me on YouTube, I do have a video out that goes into the very first section of the Citizenship Act of 2021. Please do give me a follow on YouTube and please check out my video. I have lots of videos going on and I'm going to be doing a whole series on the Citizenship Act because this whole act is almost 300 pages long. I'm only halfway through. There is so much to go through in it. And, I'm excited. I think that there are some really good things in it. This act is not a wholesale granting of immigration status or legal immigration status to everyone. And I'm going to explain exactly what I believe it means so far. So, all right. So hi to everyone who's joining. Hi, Adelia, Asail, Rhiannon Plunkett, Sherry. Hi, how are you? It's really nice to see everyone here. And this is one that I want to address because on my YouTube video that I posted yesterday talking about the Citizenship Act of 2021, somebody said that I didn't know what I was talking about, that I didn't mention anything about granting of status to 11 million undocumented people. And here's the thing, I've said this before, and if you even go back to the fact sheet that President Biden did release back on January 20th, there is no wholesale granting of a green card to every single person who's here undocumented. All right. And that's exactly what this bill really puts out. It says that it will be granting lawful prospective immigrant status to certain categories of people. And I can go ahead and break it down for those of you who are interested. But just what I would say is go back and watch my video. I've read the bill very closely, and the law prospective immigrant status, if you're eligible for it, then it does give you a pathway to getting a green card and to getting citizenship, but it's not available to every single person. The people who will be eligible to receive lawful prospective immigrant status underneath this new hopeful immigration law are people who arrived underneath age 18 pursuant to the DREAM Act portion of the bill, persons who have TPS pursuant to the American Promise Act, and agricultural workers. All right, so that's it. Please go ahead and follow me on YouTube and check out my video if you want some more information. So I'm going to go ahead and ask some more questions, but if you guys want to talk about the bill, go ahead and ask me questions because I've done lots of research. I've been reading and reading. Amir, hi, how are you, my friend? All right, I'm just going to start answering some questions. And for those of you who are joining me, it is today is Saturday, and I just couldn't wait to come back and talk immigration. All right. All right, let's see my first question. I have a question from Shazad who's asking, hi, I applied for asylum in 2014, but my case is still pending. No interview. What can I do? Every year I have a work permit. I have my family and kids. Shazad, thank you very much for your question. So for those of you who have applied for asylum, you may have been waiting for a very long time, and this is actually just the way that it is. So there came for persons who applied for asylum, who basically, underneath Trump, what they wanted to do, of course, they want to discourage any and every sort of, immigration process. And what they believe that people were doing is they believe that people were filing for asylum in an effort to just stay in the US longer and get a work permit and all of those things, which is not actually, not necessarily true. And in an effort to discourage people from filing for asylum and finding a way to stay here longer, they basically instituted what is called the last in, first out rule. So those who filed for asylum, after 2017, 2018, they the first ones to an interview. So typically, if you file for an affirmative asylum application, you might be waiting years and years for your interview. And as a result, you're here years and years with a work permit and here with your family. And in an effort to discourage that, they were basically giving interviews to people sooner rather than later. So if your case was filed before 2017, then you're probably going to be waiting a very long time, Shazad. And also the thing is that with this COVID-19 backlog that has occurred. You might be waiting even longer. If you want to speed up your application and get an interview even sooner, you can request it due to some sort of need. Will be with the discretion of the asylum office to give you an interview. Now, of course, if your case is in court and you're in removal proceedings and you want to speed up your hearing, you can also make a motion to the judge to advance your hearing. But everything is messed up. Everything, all the systems are backlogged. Judges are not, not all the courts in the U.S. are open for immigration. So good luck. It's just, I know it's very hard. You just have to have a little bit of patience, or even more patience, because you've already had a lot of patience so far. Take the time that you have to keep making your case stronger to make sure you have your evidence, and be ready when it's time. All right. So I have a question from JD Cienfuegos. We went to the interview for an I-130 marriage visa interview. It went so well, but no officers. The officer said she was going to review our document. Okay, JD, I hope I'm pronouncing your name correctly. Thank you so much for watching on YouTube. So if you have gone for your interview for an I-130, for an I-485, for any sort of immigration application in front of USCIS, should you expect? Does it mean that you're going to automatically get something approved? Are you going to get your card right away? Will you get your result right away? Here's the thing. Officers have to go through their own channel. They have to sometimes get supervisory review. And also sometimes, they get backlogged as well. They can, they might have other cases they have to do, and they might not have time to get around to your application. And if your case has certain other complications, they might need to get a supervisor's review, which is going to add to the time that it takes to get a decision on your case. And if that is the case, then you might be waiting several months for a decision. Normally what they do is they might give you an interview, a letter after you finish your interview that says that please allow 120 days after this interview to before you contact our office for a decision. And what that essentially means is that the government wants you to give them a little bit of breathing room. They want you to back off and don't make an inquiry on the case until 4 months have passed. I'm not saying it's right, but that is why they give you one of those letters. So if it goes beyond a certain period of time, you always have the power to reach out to USCIS to make a service request by calling them on that customer service line. And if it goes even beyond that, you can also reach out to the ombudsman and to your state senator for help on your immigration case. Okay, so I hope that helps. I'm just going to some questions on Instagram and TikTok. Okay, let's see. And thank you so much to everyone who's joined. Okay, Spider-Man 2994 is asking, my husband was deported in 2009. He came back, then we decided to get married in 2017. So Spider-Man, I'm assuming that you want to see what is possible. So definitely your case needs a consultation, because we need to see when your husband was here, how long he was here, when he came back, and what happened in between. And depending on those factors, your husband may have certain bars. He may even have the permanent bar. And, if he does have the permanent bar, there are actually 3 different ways to fix the permanent bar if he qualifies. There's something called a T visa for trafficking, which can include labor trafficking or sex trafficking. There's also the U visa if he has been the victim of a crime. And there is also an I-360 case where if you are married to a US citizen or to a green card holder, or you have a child who's at least 21 and you have suffered certain problems in your relationship with them, then that can be the basis to get approved for a green card and possibly overcome that permanent bar. So definitely give me a call, Spider-Man. I would love to talk and see what your husband qualifies for, okay? Thank you for your question. All right. So from Jessica, JM's asking, hi, my question is, my husband has been here for 15 to 20 years, but he never got in trouble. Please help us. All right, Jessica, thank you so much for watching. I would love to talk to your husband about what his history is in the US, when he came in. There's a lot of things that need to be looked at to see what he's eligible for. But Jessica, if you are a US citizen, then he may have certain options available to him. He may be able to get a green card in the US. And if he's not, then I'll look to see what he qualifies for. So you can call me anytime, 212-248-7907, and schedule an appointment with me. Okay. All right. Let's see what I have. All right. So I have a question here from Wahid, who's asking, my asylum case is in Ohio and my individual hearing was in March 2021, but now they changed to 2022. I want to move my case from Ohio to New York. Can I expedite my case there in New York? Wahid, thank you very much for your question. I have a feeling that if you do move your case Well, first of all, if you're in removal proceedings or if you're doing anything with immigration, your address always has to be up to date with them. You are actually required by law to update your address so that they know where you are. And if your case, if you happen to move to certain parts of the country, then it may actually cause your case venue or your case jurisdiction to change to the other place. And if you're moving from Ohio to New York, then yes, you should be filing a change of address because that is the law, that is the legal requirement for you. And that will most likely cause your case to get transferred to New York. But New York, the New York courts are not even open right now if you're not in a detained case. And they're going to be very slow. We have one of the busiest immigration courts in the country. Probably, I think the busiest one is maybe LA. I don't know. And then New York. Of course, New York is New York. We know we have bigger everything, right? So if you're going to move to New York, your case is going to get transferred. Legally, it should get transferred. And you probably end up waiting longer. But thank you for your question. I hope that helps. All right. So Sukhdeep Singh is asking, hello, ma'am. I have one question. I have a marriage green card. Can I travel with the travel documents? All right. Thank you so much for your question, Sukhdeep. So if you have a green card, you do not need a travel document. Your green card is basically a travel document. However, if you got your, you need to have a passport along with your green card. So that's probably what you're asking. You don't need to apply for any separate applications. Your green card and your passport will serve as your valid travel documents. All right. Thank you for your question. All right. So let's see what I have. All right, Parul Patel is asking, I'm a sophomore in high school right now. Do I qualify for the DREAM Act? Please answer. Thanks. Parul, thank you so much for asking. All right, the DREAM Act. The DREAM Act is one of the parts of this Citizenship Act that has been presented to the Congress. And the DREAM Act, basically what it says is this: persons who arrived underneath the age of 18 into the US, basically they'll qualify for lawful permanent, lawful prospective immigrant status, which would then put you on the pathway to a green card. So yeah, I mean, Parul, if you came in underneath the age of 18, then you may qualify. There are some other things that you have to show, such as, finishing high school and college, or a combination of college and military service or work. There's a few other requirements in there in the DREAM Act. But if this becomes law, then yeah, Parul, this might be a way for you to get your status fixed. All right. Oh, I've been neglecting my my Instagram followers. All right. Let's see what else I have. All right. So Flora is asking, hello, will people still have to leave to Juarez for their interviews? Also requirements to be a sponsor? All right, Flora, thank you. So from what I'm reading in the DREAM Act, there's no waiver of the, from what I'm reading in the Citizenship Act, there's no waiver yet of the requirement to consular process. That is something that I have to read further into. I'm only halfway through these 367 pages. I'll let you all know. All right. Biraj Shrestha is asking, how long until we see some parts of this new bill being the law? That is the question of the day. How long will it take for this Citizenship Act of 2021 to become law? Oh my God, I have no idea. I mean, even though we have a majority, we hold a majority in the Senate right now, it still requires 60 votes. That's tough because honestly, this is a very, very liberal piece of legislation, and it's going to take a lot of work. Who knows how long it's going to take, but hopefully at some point in the next 1 or 2 years. Okay, so let's see. Oh, so Chris Whitnow is asking, saying family member got sent to Juarez, but got found with marijuana in his system, and now he has to be there for a year. Yeah, so those of you you have to go to Juarez. Ciudad Juarez is one of the toughest consulates. People can get denied for so many reasons. Having weed, alcohol, tattoos. There are a lot of reasons why people get denied, and I do feel that the consulate in Juarez is one of the tougher ones. And, that's one of the reasons why, whenever people come to me, I always look to see if there are ways that we can qualify them to do the green card process inside the US without them having to leave. That is one of my biggest things because, I believe that not enough attorneys actually check to see if there are ways for them to do certain other cases in the US. And if you're eligible for it, then you should definitely go for it because it once you go to Juarez, once you go outside the country, and if you already know that you need to have a perdón or a waiver, that means that you have to leave the U.S. And once you leave the U.S. and you go to the consulate overseas, there's not a guarantee that you'll get approved at the consulate. There's not a guarantee that something might not happen to you that might cause your case to get denied and might cause you to need another waiver. And then that could mean many years of family separation. And also, it's important to note that a lot of people get sent out of the US by their attorneys by accident when they might have something called a permanent bar. If you have the permanent bar and you leave the US, well, it's going to be a 10-year wait before you can come back to the US, which is why it is better to see if you qualify for, make sure, first of all, to make sure you don't have the permanent bar before you go outside. And second, to make sure that you explore all case types that might be available to you to see if you can do something here. So yes. So I did have a question on Instagram from Meiji who's asking, hi, I'm from South Dakota. I work as a farm secretary and have legal work permit. Do you think I will qualify for the farm work bill? So yeah, I do think that if you are working in agriculture, so the farm workers, the agricultural portion of the Citizenship Act does provide a pathway to a green card for persons who either provide labor or services in agriculture. And there's an hourly requirement. I think it's 400 days of labor or service or 2,300 hours, something like that. But if you are a farm worker, then you will qualify. And another thing that's not being talked about enough is that, if, within this Citizenship Act of 2021, if you actually qualify to be a lawful prospective immigrant, then your children and your spouse will also qualify to be one as well, and they don't need to independently qualify for a green card on their own, which is really great. I love it. So even though the Citizenship Act of 2021 is not widespread, it is not. I just want to make this clear because people are disagreeing with me and telling me that I have it wrong, but I don't have it wrong. I've been reading this, and I read federal codes for a living, guys. So, this act only grants, yes, it says that it's going to grant green card and citizenship, a faster pathway to citizenship to people who are undocumented, but only if they qualify for lawful prospective immigrant status. And basically, they say that the people who will qualify for lawful prospective immigrant status are persons underneath the DREAM Act, the Farm Workers Act, and the Promise Act, which is the TPS. And that's pretty much it. It's not a wholesale, amnesty. So, but then again, if you happen to be married to somebody who qualifies, or you are a child of someone who qualifies, then that's a really great way to keep your family together and to make sure everybody gets status. All right. So what questions do you guys have? Tell me. All right. So Love is asking, is the CR1 visa that my husband will be getting for a marriage petition? So when you file for a green card through marriage, if your marriage is less than 2 years old at the time that the application is granted, so if you're doing adjustment of status in the US at the time on the day of your approval for your green card, or if you're outside the US and you're coming in on the immigrant visa, the day that you come into the US, if you're still underneath 2 years of marriage, then you will not be receiving a 10-year card. You will be receiving something called a conditional resident card, which is valid for 2 years. And that is the category CR1 or CR6. All right, so Andrew's asking, I have a question. My mom's case is approved from NBC, and now I'm waiting for the interview. Can I request an expedite for her interview? Yes, thank you so much for watching, and thank you for your question. So if you are waiting for an interview, or your case got to NBC and you need it expedited, you can request an expedite, all right? You can request an expedite. Your expedite request usually has to include some sort of basis for the reason why you need to have your interview expedited. And that is usually based on some sort of emergency, some sort of urgent humanitarian need, or some sort of medical need. All right. So you can request it. It never hurts. You've got nothing to lose. Either they approve it or they don't. If they don't approve it, then you'll just be waiting. And if it is approved, then you'll end up having your interview quicker. All right. Cadenes, thank you. Your question is, I hope you're well. For the Santo Domingo Embassy, are they scheduling interviews for CR1? So Karen, thank you so much for your question. So most of the consulates are actually scheduling interviews for immigrant visas for immediate relatives. And if you are applying, if you're supposed to be receiving a CR1 visa, then that means basically that you'd be a conditional resident. And normally, immediate relatives are conditional residents. So yeah, so I hope you'll get your interview soon. Chandumo, thank you so much. Is F2A current right now from Rahima? I believe it is, but you have to check the visa bulletin. All right, guys, so that's it. I'm going to go ahead and call it a night. I hope everybody enjoys their Saturday. I will see everyone soon. Take care and see you next time.